saying that she never participated in the transaction. Does her or did her evidence matter in the proceedings as a wife when it comes to transfer of or sale of land? You didn't give an analysis why you didn't believe her statement, but I just want to understand why, whether her evidence matters, spousal evidence matters.
I think what they were proving, the wife and the defendant, was fraud. Because what they put there as in particulars of their defense were particulars of fraud. So the evidence of the wife was coming to say that there was fraud because I did not participate in the matter.
Yes.
Yes.
So did it matter, her evidence?
Maybe one can now talk about the issue of whether spousal consent would have come in. But for me, what I analyzed and what I saw as part of their pleadings and what they were talking about was the defendant saying, these consents that are signed, these transfers that are signed were forged. That is what he was saying in the counterclaim. And in the plaint and the evidence by the plaintiff, I was convinced that
she was not telling the truth.
Yes, that the transaction went as required by the law.
Okay, and among the orders the plaintiff was asking from the court was an eviction order.
Yes.
And a permanent injunction. In your decision, you went ahead and just said the plaintiff has proved this case on balance of probability, and judgment is entered as prayed in prayer A and B of the plaint.
Yes.
What are you supposed to do before you issue an eviction order?
I now know that after there is a decision, and then later there was the amendment to the Land Act, that is 152 to I think L, that now there are issues of notice, that before eviction there will be a 90-day notice, that even if the court finds that these people are illegally on this land, there are rights that have accrued to them. There is the aspect of humane treatment to people who are being evicted, even from land that they do not own.
So this one you ought to have given that notice?
Yes, only that maybe I'm thinking that was before then. I'm not sure about
it. It was after the amendment?
Yes.
Okay.
Yeah. And
lastly, who is an intersex person, and do they have rights under Article 45, Sub-Article 2 of the Constitution?
Intersex person is a person, I think, the intersex as a gender have now been recognized in Kenya. This is a person who has both male and female, presents both male and female genitalia, and therefore cannot be grouped exclusively as female or male. Mm-hmm. So it comes to
on a genitalia or other differentiation.
I think
yes,
could also be hormonal, that this person looked at wholly does not fall on either side.
Okay.
Yes.
So does such a person have a right under Article 45(2), that is the right to marry?
I don't see any reason why that person will be prohibited from marrying.
Explain your answer. Maybe you can make reference to what the Constitution speaks about. You have the Constitution there, 45(2).
Yes, I see that, Commissioner, that the Constitution gives the right to one to marry a person of the opposite sex. That seems to present a problem in that once we identify them as to be not of one of the two, then that will be an issue as to accessing, that right to marriage. But my thinking is that if we look at the Constitution holistically and say, these are human beings. Why would we, on the basis of the way they appear, because intersex is not even a matter of choice, why would we say that because this person was born this way, then just by that accident of birth, they are precluded from getting married? I think it's a discussion that I do not remember as at now seated here, whether it's a matter that has engaged superior courts in terms of that right to marriage.
Okay.
Yes.
Thank you. And I also must commend you for the work you do. Members of the Law Society in Mombasa are okay with how you manage your court and the stakeholders. I wish you the very best.
Thank you. Thank you, Commissioner.
Thank you. Yes, good morning again.
Good morning, my lady.
Please, if you are able to, in a nutshell, take us through the process of removal of a judge from the beginning to the end.
Thank you, Commissioner. I think removal of a judge and Article 68 starts with maybe a complaint that goes to the Judicial Service Commission. The Commission will look at that complaint and do an investigation. I think that investigation will involve the judge getting also to give his view, to respond to the complaint. Once that is done, then the commission looks at the complaint and the response, and on its finding makes a decision whether this is the kind of complaint that they should recommend to the president to form a tribunal. And once they pass that recommendation to the president, then the president will form a tribunal where the judge will be heard. And after hearing by the tribunal, then that tribunal will recommend whether the judge should be removed or not.
Is that the end of the process?
After that, if the recommendation is removal, then the judge is removed.
Does the judge have a right of appeal?
The judge has a right of appeal to the Supreme Court.
Okay.
Yes.
What standard of proof does the Supreme Court, did the Supreme Court say must be used in terms of removal of judges? What is the standard of proof to be applied?
It's a standard that is above balance of probabilities. Okay. I would call it intermediate.
Now, one interesting thing the Supreme Court has found is that the parties that come before the Supreme Court in an appeal of such nature will be the tribunal,
yes,
and the Judicial Service Commission, but the complainant, the original complainant, is not a party. What do you think of that in terms of a complainant's rights or victim's rights? What do you think of that? Do you think that the complainant also ought to have a right to address the court at the appellant level?
My feeling is that they should, because that appeal, the appeal before the Supreme Court, if it's successful, it takes the matter back to where it started. I mean, the judge goes back to office. And at that point, although the complainant was heard, its complaint was processed all the way and was heard by the tribunal. But I think it will, in terms of just the victim, getting to hear the victim, in my view, it will be fair if the complainant gets an opportunity to hear and respond to what the appellant is telling the court at that level. I know the complainant, the appellant mostly will be appealing against findings of the tribunal, not what the complainant said or did not say, but what the tribunal finally resolved. But I think in terms of just all-round justice and fairness, no prejudice will be suffered by hearing the complainant.
So in the same vein,
Yes.
would you also make the suggestion that even in criminal appeals, for example, the victims ought to be present, so that in a criminal trial,
Yes.
an accused person is convicted, then he appeals or she appeals,
Yes.
but the victim is not present, and therefore if that person is acquitted, the victim has absolutely no knowledge. Like, for example, in sexual offenses, you find that sometimes an accused person who is maybe even coming from the same village as the victim
Yes.
is acquitted, and the only way that the victim knows is to see somebody showing up in the village who they thought had been convicted at trial, and there is no information thereafter. In terms of victim rights, how do you think that should work?
I think it's something that can be explored, though your lordship. There's also the issue around efficiency. Without sacrificing, of course, the rights of the victim, you'll find that at the time this matter is at the appellate stage, whether it's the High Court, Court of Appeal, or the Supreme Court, there is the trial of facts at, if it was in the magistrate's court, where the victim participated fully, the victim was heard on all the facts, and then the opportunity to participate. So that, in as much as I will still say that I see no harm, especially if the victim can just be allowed to file their submissions or just address the court on what has been said around that time. I also see that aspect, that in terms of just the efficient administration of justice, the system could be clogged with those applications and appearances that when you look at it more, the complainant, the victim, and most of his or her interests or the aspects where she was interested or is interested addressed fully at the trial stage.
Thank you very much.
Thank you.
Thank you, my lady. Good morning once again, Honorable Ithuku.
Morning, Commissioner.
Yes, I have your returns here from diaspora. I don't know if you've seen a copy.
I have.
Yes, and you're happy with the report?
Generally.
Okay.
Yes.
So, according to the report, your court seems to be doing fairly well. I can see your case clearance rate is above the national average, which is commendable. At the same time, the court productivity is also above the national average, which is good. I'm looking at your own output, and it looks like you're not carrying your weight. As such, you are 1% shy of what was expected. You are expected to carry 7% out of the resolved cases. This is for the period between 1st July 2025 and 31st December 2025. Your output is 6%. I don't know if you want to make a comment on that.
Thank you, Commissioner. Let me comment. For the last 2 years, your Lordship and Commissioners have been handling the Shakahola case. Now, that case, almost every month, we take either a week or two because of the magnitude. In fact, as I'm seated here, on Monday we are taking 2 weeks. We hope to close, having had just over 100 witnesses. Now, because of the nature of that case, we agreed with everyone involved, the defense, the prosecution, that we give it priority. So it has taken a bit of my time of what I would have had, because Commissioner, if you look at my records prior to that, I used to carry even more than my weight. But I would say that's one of the reasons, and it's a major one, because you see, even though that's a major case, you are hearing many witnesses taking so much time, it will not come to that record as matters finalized, because it's not yet finalized, but still taking a lot of my time. I also do a number of ESCC matters that also seem not at that Shakahola magnitude, but it also seem to take a bit of time. I'm also the head of station of Mombasa, but I work. I'm not giving those excuses.
Okay.
Yes.
We've heard you on that. I think that's why we are even having a discussion around here about case waiting, because these results are based on treating each case as if all the cases are the same. So we hear you when you talk about the scenario you have with Shakahola. So moving on to something else, I want to give you a scenario. You just want to test how judge ready you are.
Yes.
So you are appointed as a judge, posted to a station where you are the only High Court judge, and you do a case audit, as I expect you would do if you're successful, and then you find in your docket you have 2,000 P&A cases, succession cases, both contested and uncontested. You have 1,000 civil cases and about 200 murder trials. And so maybe you can just walk us through how the practical steps you'll take to organize yourself so that you expedite the resolution of these cases.
Thank you, Commissioner. After the case audit, what of course will come out, as usually does, is the length of time each of these cases has taken in our docket. And therefore, the first thing I will do, because many of those cases I expect now that at a High Court level will be represented, is hold a meeting, a stakeholder meeting with the bar, where we will agree that these matters that have taken time, we will prioritize them, and then we get them off the list as soon as possible. I know also, especially because you've mentioned P&A, and it's something we've dealt with, that what happens in many of these matters is that once people get grant, they tend to disappear. So you might find that there are many of those succession matters where the only thing you have is a grant. And these people have not come to court for 6 months, 3 years, or something like that. Now, that will have to take action in terms of giving notice, because as it happens now, we have a system that shows the addresses of everyone. It's now part of our registry manual operation, that by the time we're filing a succession matter, can we have the address of either the administrator or... So we'll use that to give notice to those people, take dates, so that they come and we get to clear those matters, whether it's confirmation, whether there are objection proceedings that have been pending, and then that way we'll be able to handle the backlog and have now a docket that is clear. All matters have dates, all matters have been dealt with. There is a possibility that sometimes we issue these notices and parties don't come, or they cannot be found, or you realize actually the reason this administrator has not come all this time, he passed on. So when you have that information, then you can deal with what is in your docket, so that matters are not on the record looking as pending when actually there's nothing pending.
Yes, actually that was going to be the next limb of my question, but before I go to the next limb, I wanted to also point out, as you go through your succession docket, remember I said contested and uncontested.
Yes.
Sometimes it's better to get rid of the ones that don't have issues, so that you quickly conclude them as you deal with the contested ones.
Yes.
But now, suppose someone doesn't come after you, you are right, you serve them with a notice. I think it's under section 74, 73 of the Succession Act, the Law of Succession Act. Yes. So they don't show up. Just as you said, because often that will happen. What do you do?
Now, they have not shown up. We don't know why. But they have left the grant unattended all this time. For me, I think now I'll fall back to Section 76 of the Law of Succession Act. That is a grant that has become inoperative. And what I'll do is revoke it.
Okay.
Yes.
Revoke and close the file.
Yes.
Okay, thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Mheshimiwa.
Thank you.
Would you tell us